Let's discuss this lecture, employment discrimination. I would like to talk about those types of acts that you as an employer may not undertake. You're prohibited from undertaking against specific employees and the reasons for that. I think the reasons for the rationale for these anti-discrimination laws are really self-evident. I think it should be very obvious to everyone why we have them, the social good, the moral good, and the legal good that these laws have. So let's cover them. Title VII of the Civil Rights Act. You often hear Title VII actions. That's just a section of the Civil Rights Act, and basically it prohibits you as an employer to discriminate based on race, sex, color, religion, and national origin. Let me cover them again. Race, sex, color, religion, or national origin. If, for whatever reason, you happen to fall within one of these categories, you are a protected class. You're a member of a protected class for purposes of our lecture and for purposes of this law. Discrimination. Basically, that subsumes activity by employer where you're treating someone unfavorably. You don't hire them, you don't promote them, you harass them, etc., because of race, color characteristics, etc. Color discrimination literally has to do with skin color, complexion. It can also involve discriminating against someone because they're married or have a significant other that's of a protected class. Okay. Harassment. Similarly, we cannot, not only should not, what I'm telling you is not what we cannot under law. Obviously, it goes without saying we should not. But we, as an employer, we cannot harass someone due to one of these protected class reasons. No racial slurs. And when I say we, I mean not only you as a manager, but you need to protect your employees as well. You need to make sure that you have policies, employment policies, training, etc., and not so the employees know what is prohibited behavior, and that if they don't follow it, there are consequences. They could lose their job. They could be, put on leave, have to go through sensitivity training, etc. So you as a manager, you're going to have responsibility for overseeing this, the implementation of these programs. Now, when we talk about harassment, that's not simple teasing, but if someone believes that it's a hostile work environment is the best terminology that you will hear. Repeated harassment, demotion, failure to promote, but you always hear really it's usually more verbal, or somebody might post something. That's definitely harassment. And it doesn't have to be a supervisor. It could be the harassing party or harassing person can be a supervisor, a coworker, a customer. If you permit, for example, if you're at a restaurant, you have a certain customer that comes in all the time and just harasses sexually or for one of these protected class reasons, harasses a waitress or waiter, they could have a cause of action against the employer. If the employer's on notice at repeated behavior, does nothing about it, you may have a right to sue your employer, not just the jerk that comes into the restaurant. You can't have employment practices and policies that adversely impact someone from one of these protected classes. Okay, it has to be. I believe it was San Francisco Fire Department maybe case where they had a no beard policy, and a court actually held that. And again, this is just an example of this case, so I'm just reporting cases that at that time they said African American, that this was discriminatory against African American because some were more likely to need to wear a beard because of skin condition or something, severe shaving bump. So that was an instance of where a policy didn't seem to have an overtly racist intent, but in fact it did have an adverse impact on a person that would fall within a protected class. Sex discrimination, I think we all know what that is. I've put you'll see in the materials a link to the Equal Employment Opportunity Commission where they have a good description of what is sexual discrimination and everything from LGBT rights and et cetera, so that they do a good job of outlining what type of behavior you should make sure are within your policies and your practices and your companies, not only because it's the right thing to do, because you have to legally. Sex discrimination, sexual harassment. Let me be very, very blunt. Unwelcome sexual advances, requests for sexual favors, or other verbal harassment. There can be a couple of types there. One's kind of called the quid pro quo. I'll give you more favorable job treatment for such and such inappropriate behavior. And there's also the general, all the people are just saying, really offensive things that bother 1, 2, 3, however many individuals. That's a hostile environment. So a quid pro quo or a hostile environment. Religious discrimination is a problem. We can't discriminate against someone based on their religion. So let's say, for example, that it is reasonable for someone to pray 5 times a day. In other words, on the job, they're not in the middle of surgery, and then have to stop and engage in religious practice. Probably under U.S. law, that hospital might be able to forbid that you stop in the middle of surgery for that. But if you're in manufacturing and everybody else gets breaks, that may be a reasonable accommodation to permit a break for prayer, during the workday. That's an example of a question we would encounter in the religious discrimination context. Segregation, we don't segregate. I can't remember who it was. I think there was an allegation that it was one of these stores that one sees in a shopping mall that hired, certain people. I forget what the name is, but their models seemed to all be, young men with their shirts off. And so you probably know what the brand is. But in any event, there was a question whether they were discriminating if you were wearing religious attire, if you were Muslim, more fundamentalist, and you wore certain attire, that they wouldn't hire you even. So that obviously is problematic and is a discrimination based on one's religion. And that attire doesn't interfere with the job, performance of the job. So you can see how that is problematic. So your grooming policies, make sure that dress and grooming policies, make sure that it's, doesn't discriminate based on religious grounds. Okay. Now, who is subject to this Title VII of the Civil Rights Act? Well, obviously every public employer, but for private employers, it's definitely for those that have 15 or more employees. Now, let's say you only have 10 employees, but you engage in this. That doesn't mean that the employee against or who is discriminated against might not have a state law cause of action or another tort cause of action for this wrongful treatment. We're tonight talking about what is the federal rights that apply to every private employer with 15 or more employees and to all public employers. National origin, you can't discriminate against somebody because they're from a particular part of the country, your own country, or part of the world. Ethnicity, accent, etc. National origin, so I'll let you look through that. Title VII, again, that's the law that you need to reply on. Now on this slide, page number 7, this is a couple of interesting YouTube videos, because prior to the Civil War, and especially prior to the 1930s, there was a much stronger identity of individuals as citizens of a state, not so much citizens of a country. So if you lived in Georgia, you really identified yourself as a Georgian first and as an American second. Now, today with national broadcast and internet and all the federal laws that are applicable to us, it's kind of strange. That seems foreign to us, pardon the pun, because we view ourselves as probably U.S. citizens, those of you that are, first and foremost. But so these are just a couple of videos to watch that basically explain why can the U.S. apply these federal laws to, let's say, for example, a company that operates only in Oklahoma. In other words, if let's say you work at an agricultural co-op or a farm that has 16 employees, well, how can that federal law apply to you? You grow wheat in Oklahoma. Everybody's from Oklahoma. You sell only to farmers in Oklahoma. Nothing goes between states. So in other words, theoretically, there's no federal involvement. In the video, you'll see a thing called the Commerce Clause under the Constitution. So these do sort of a nice segue into why are the feds able to be involved in what appears to be purely activity within one state. And this does a fairly good job of describing that. So go ahead and watch those videos. Pause this. All right, welcome back. Let's say that you are the employee. Let's take off your hat as an employer and say you're now an employee. What do you do if you've received discrimination? Well, you go to the EEOC, the Equal Employment Opportunity Commission, and usually you would go to the state version of this, but sometimes federal, but you actually proceed before them to make an administrative complaint, if you will. All right, next issue. Intentional versus unintentional discrimination. And man, is this a minefield of issues. Intentional discrimination, I think, is very easy to understand. Someone is just a jerk, for example, and harasses a coworker or is racist or whatever. That's an intentional discrimination that's fairly easy to understand. But a little more difficult to understand is unintentional discrimination. That is where a company might set up a policy, for example, and they might not have an intent that has any discriminatory impact, and they might not think about it or foresee it, but then they might later discover, or an employee might bring to their attention that, well, it has sort of a disparate impact. It affects people differently, including people within one of the protected classes. So let's go ahead and watch those and then return to the lecture. All right, as you've seen now on these videos, intentional discrimination can be disparate treatment. I'm overtly and purposely treating you differently. So let's say that you've gone through the EEOC and now you have the right to sue your employer. What does that look like when you're in court? Is it just like I see on TV, plaintiff, defendant, you bring in your evidence, you bring it? Yes and no. First, usually it would be in federal court instead of state court. Usually. Why is that? Because it's a federal question. You're probably claiming a violation of your federal civil rights. So you would probably start in federal court. But the courts since 1973 have said, unlike, hey, the plaintiff, the person that's suing, comes and puts on their evidence, and then the defendant puts on their evidence, then it goes to the jury or the judge. We're going to we think it's appropriate to do it in a different way. We're going to have a shifting burden of proof or shifting burden of evidence. You got that? A shifting burden of proof or a shifting burden of evidence. What does that mean? The plaintiff, the one who says, there's been discrimination against me, he or she makes out their case. It's called a prima facie case. And they have to prove, for example, if they weren't hired, these 4 things. All right? So she'll put on evidence, testimony, documents, etc. Now, so in other words, the plaintiff, he or she doesn't have to prove the whole case. She first proves, look, it fits the categories. I've checked the boxes. It looks like discrimination. Looks like a duck, acts like a duck, it's a duck. So it looks like. But then the employer has the chance to put on their evidence and say, wait. I'm going to articulate a legitimate, non-discriminatory reason that we have this policy. For example, you work on a line and you have to, on part of this manufacturing line, you have to lift over 80 pounds or something like that routinely. So that's part of the job requirement. So let's say, and again, I'm using gender stereotypes. Let's say that fewer women on average could lift this 80 pounds all day than could a male employee in general, generalizations. And so the employer, when they have that as part of the job description, maybe a female employee, potential employee doesn't get a job, says, wait a minute, the fact that you have this 80-pound requirement affects more women or eliminates the possibility of employment for more women than it does for men. Well, the employer says, you're right, I admit that, but this is part of the job. We don't have a choice. They have to take it from this machine to that machine. So that might be just as, a cursory example of how the employer come back and say, yeah, it does affect women worse than it does men, but this is why we have to have it. If the employer can come back and meet that burden, here's the reason we do it, it's really not for discrimination, then the plaintiff, the burden goes back to the claimant, the person who didn't get the job, to prove, wait a minute, what the employer said was just a pretext for discrimination. It's not real, or, the real reason they're doing it is for discrimination. So that's the shifting burden, this 3-part. Now, you'll see as we go through this lecture, in different types of employment discrimination lawsuits, they follow the same formula. I'm not going to bore you again on the others, but you'll be able to see it on the slides. Unintentional discrimination that is disparate, depending on where you part of the country you're in, impact. It's when a group is disproportionately impacted, even though just on the face of the policy, for example, the work policy, it does not appear to be discriminatory. Okay. So in this instance, an employee, the person doesn't get the job, they don't have to prove that the employer intended to discriminate against them. They just have to prove that the impact of the policy had that disparate impact. The beard was a good example. They could say, yeah, we know the San Francisco Police Department didn't intend to be discriminatory. Maybe they thought it was safety, less facial hair means less likely to actually get your face on fire. Or, no, I remember what it was. They were argued that you could get a tighter seal with the breathing equipment. But the court said, we get it. We know you didn't make the policy intending to discriminate, but it did have that impact. So how would that employee or potential employee that didn't get the job, how would they prove that it has this impact that's unfair, if you will? Well, they can do a couple of things. They can do the pool of applicants, okay? So they look at the workforce, look at your workforce, and let's say we live in Oklahoma, and I'm just going to make up numbers. 30% of the people in Oklahoma are purple, 70% of the people are green in Oklahoma. But when I come look at your plant, 90% of your people are green and only 10% are purple. Well, that appears to be discriminatory, the implementation, of your policy. Rate of hiring, again, it's similar, but the selection rates for people within a protected class, to show that it's below certain percentages, that seems to be evident. So now when the employer gets on, remember the shifting burden. So we've just gone over phase one, what the claimant shows. Well, when the employer comes back and says, hey, no, there's a legitimate reason, at this point, the employer has to say, we have and I'm going to read this exact language for you, a bona fide occupational qualification. You hear sometimes BFOQ, bona fide occupational qualification. Say that real fast 3 times. So basically, the key is we have to have it in this job. There's some examples that I've seen here. Mandatory retirement ages for pilots or drivers. That's a little iffy to me, but there's probably because I'm older, but there's, if you get to certain ages, then indeed your reaction time is less. Hearing and sight might be more difficult. So that's an example. Religious affiliation. Let's say a Catholic parish is looking for a new priest and they don't hire a Protestant applicant. Well, the fact that he's Catholic and he's a priest is a bona fide occupational qualification to be able to be a priest. So those are the type of things that you could say, look, I get it. We get that it has a discriminatory impact, but there's a legitimate reason why we do it that way. Okay. And then again, you see step 3 when it goes back to the claimant or the plaintiff, the person that didn't get the job, what they have to do. There's this slide 18 is just going to show you that the federal section, what you can claim, a section 1981 claim, they call it. It's similar to the same thing. I've been a victim of racial or ethnic discrimination, and so that's a basis for me to sue the company that didn't hire me or didn't promote me or fired me or whatever for inappropriate reasons. We already talked about an employer must reasonably accommodate certain things, health things, religious-based things, etc., if they're reasonable accommodations. Okay. And that's a fact question. What's reasonable, what's not? And frankly, 2 judges may find the same thing. One may find it reasonable, one may find it unreasonable. Let's make an example. On my job, I tell my boss I really need to go smoke weed every 17 minutes because I'm in the Church of the Holy Weed Monster, something like that. And then when the employer won't do it, I sue them. Well, must my employer allow me to go toke up every 17 minutes? Is that a reasonable accommodation? Probably not, because it would be such a disruption in the workforce. Even if potential impairment from smoking is not an issue, that every 17 minutes is not reasonable accommodation. And then there's the second question of is it a sincerely held religious practice? That's a little tougher because you start questioning an individual's subjective beliefs. That's a little tougher for an employer to dispute. Gender discrimination. Again, gender essential to the job issues. An actor, let's say that I am hiring, I'm casting for a movie and I have a male romantic lead and I have a female romantic lead. Well, I would suspect that even in Hollywood, courts would protect the employer, in this instance the Hollywood studio production company, right to hire the gender, or at least someone who appears to be the gender of the desired role, the male lead or the female lead. Okay, I'm not saying they have to be that sex or that gender, I'm sorry, but to at least the appearance, I think they would have the right to insist on it. I think that would be a job-based issue. Pregnancy, same thing. You can't be discriminating based on pregnancy, childbirth, or related medical conditions. How about some more gender issues? Equal Pay Act. Okay, basically, and here's where a lot of us in the political arena. I'm not the political arena. We're the legal arena. People can complain and have personal opinions. I don't care. I really don't. I'm here to tell you what the law is. This is the law, whether you agree with it, whether you disagree, whether it's moral or amoral, not immoral, amoral. It's the law. Well, if male and female are working at the same place doing, quote, similar work, then they should have equal pay. Well, there are a host of distinctions. For example, you can't, if it's a significantly different job, that's not a fair comparison. If the female has seniority, she's been there 20 years and the male's been there 5 years, that's a legitimate reason that she would be paid more than he would, even if he sued the company. So there's a lot of things that you have to really look at the fairness gap. There's a Harvard professor that talks about the fallacy of a gender pay gap in America. And she talks about, it's interesting because she touches on some of these legal things, whether you agree with her or not. Again, it's not an issue. And I'm not saying I agree or disagree with her. But she puts a lot of indicia like you have to make it a fair comparison. If female has been working there for 10 years and never took a break, but the male has been working there 5 years and he left for a year during his career for childcare and then he came back, well, then that cannot be a fair comparison. That you can't call that a wage gap. It has to be apples to apples. And this professor's study shows that a lot of the fallacies in the pay gap. However, I personally believe rightfully recognizes there are many pay gap issues out there that legitimately are problematic. They are problems. So what I'm trying to say is this legal analysis would get into all the variety of these factors. Make sure you compare apples to apples, if you will, is the fact-based question. As an employer, though, I would tell you, if you've got a male and a female in a similar job, if they're doing the same work and you don't have seniority-based raises, 5% a year cost of living, you better damn sure make sure you're paying people the same. It's important to do that. Don't be paying people differently based on their gender. Now, here's a really interesting development. It was in June 2020. And I apologize. My daughter, who is in her 20s, is always educating her old father. And indeed, we do need education. We need to learn the new things, how the world's changing, appreciation of individuals. I mean, that's just reality. And some of us are quicker learners than the others. But sex discrimination or gender discrimination was traditionally male-female, but there was a U.S. Supreme Court case, which means it is the law of the land now, that held, which changed the law, that says these prohibitions now prohibit discrimination on the basis of sexual orientation and gender identity. Okay? A quote, because discrimination on the basis of homosexuality or transgender status means an employer is treating individual employees differently because of their sex, it's prohibited. So please, if you're, as a young manager, if you're going into a workplace that, has older managers, which is likely, just because if you're doing your MBA, you're probably, as an average, probably younger than a lot of the senior managers there. This may be a battle that you have to fight to save the company from getting sued. So please remember this one. This is part of the evolving and changing law. Whether you agree with it or not, like I said, I don't give a damn if you agree with it or not. I'm telling you what the law is. And that is, please make sure that not just gender, but make sure that these bosses understand sexual orientation and gender identity are now within protected class, whether they like it or not. Okay. Now let's talk about constructive discharge. If you're terminated, I don't like you because you're, a 70-year-old Jewish woman. I just made that up. I'm going to terminate you. Okay. Well, that's obviously prohibited. But what if I make working conditions so intolerable for you that I don't come out and terminate you, but you basically say, I can't work here anymore. It's such a hostile work environment. I just can't work here anymore. Well, that's what's known as a constructive discharge. So you would basically come up, and if you filed a lawsuit or went before the Equal Employment Opportunity Commission, whatever, you'd say, look, here's my proof that it was an intolerable work condition, right? I just could not continue to work in this. And it should be fairly objective. I mean, if you have to quit because someone sneezes, you can't be that sensitive. It has to be the reasonable person standard. But that applies to all this Title VII type discrimination, gender, race, et cetera, et cetera. So keep that in mind, that, make sure that you don't get a mean-spirited manager that says, there's more than one way to skin a cat, pardon the metaphor, but, basically thinking or acting, we're going to get rid of somebody without firing them. The problem will take care of itself. Well, when you hear that, that is prohibited conduct. Sexual harassment, I'm going to let you watch that YouTube. All right, now we'll come back. We've already talked about two types of sexual harassment: quid pro quo at hostile work environment. Now, let's say that you're the employer and, you're not the one that is alleged to have done the sexual harassment, but it's your job to defend the company. You're the manager saying, oh my gosh, we got sued. What do we do? I'm the head of HR, or I'm a VP in this department. What do we do? Well, you have some defenses to being sued when you're sued. Okay, the first is that you had taken reasonable behavior to promptly correct. So you've got an employee that is sexually harassed, a male down on the plant floor that's sexually, awful jokes to his female coworkers only. They don't like it. Well, you see this, they've complained and complained. This goes on for 6 months. We obviously haven't taken reasonable steps to promptly correct it. Now, if the very first time you hear about this, you call this guy in and say, look, this is the deal. This is your warning. You're fired if you do this again, or you go home for a week or something. You promptly do it and give him training. You cannot do this. Then that is a legal defense, because you basically say, look, as soon as we, the company, found out about it, we did what we could to stop it so it didn't happen again. Because keep in mind, respondeat superior, think way back on agency, the week we talked about agency, you can, in some instances, be liable for what your employees do. But if you have a rogue employee out there doing things they're not authorized to do, and you have programs like this saying you cannot do that, then it's possible that there won't be damages assessed against you, the company, even if this guy's what. The second type of defense is, for example, this guy said something, on the floor. You went and corrected him, and we didn't know about it. He didn't stop, but we said, look, we're going to isolate you from this guy. Same pay. You go over here. It's the same job, but we're going to separate you from it. No, I'm going to stay in the same place. Theoretically, somebody might argue, hey, you had the opportunity to take this step to get away from this jerk just in case he did it, and you didn't. So that's not a real strong defense, but it's a potential defense that you and the employer may have. Retaliation, that's another type of sexual harassment. You got some sleazy boss that says something inappropriate, and you say, yeah, I'm married, or thank you, no, or, you show some, no, that's inappropriate. Well, what if he never, I'm being sexist, I'm doing the he and she, I apologize, but he never promotes you. He gives you the crap type of work. These are things that are known as retaliation, that your supervisor is now giving you bad things at work, or not treating you as favorably as he should. That's known as a retaliation. And obviously that is restricted. It's one of the most serious types of behavior, and it's serious for the company, because theoretically, if it comes to your knowledge, you not only allow this type of environment, but you let him target the individual and retaliate. So it's a pretty serious thing. You want to make sure that managers know they cannot do that, should not do that. They're trained, and if they do it, there has to be serious consequences to them, up to possibly firing. Again, sexual harassment. What if it's from one of my coworkers on the line? Why should the company be liable? It's some idiot on the line. Well, I can be liable as the employer if I knew or should have known it was going on and I didn't take action. Okay? In other words, I've gone to my supervisor when I was harassed and said, hey, and the company does nothing. Then the company could be liable. We already talked about there are some instances where you as an employer may be liable for customers coming in, for example, and harassing someone. The waitress example was a good example. Same gender harassment. Just because it's same gender doesn't mean it's not harassment. That's also can be harassment. There can be online harassment. You're using the company's computers or platform or whatever. You have to be careful. Make sure employees never use that to harass a fellow employee. And if you find out they are, remedial action, termination, training, whatever you need to do to remedy that. Now, let's say that you guys have that I'm in the protected class, and I am in age, and you have violated, you have discriminated against me. What are my possible damages? What can I get out of it if I pursue a lawsuit, or if I do a lawsuit, or if I go to Equal Employment Commission? Well, the things potentially that a judge or the EEOC could order is reinstatement. That is, if I got fired, I get reinstated, or if I got demoted, I'm reinstated to my former job. I could get back pay for while I wasn't employed. I could get retroactive promotions. They haven't promoted me for the last 7 years because of this. Well, I could get promotions and money goes with it. And I might get damages for other things. I had to go get therapy. I had, et cetera, et cetera. Now, age discrimination, yes, my favorite at this age. Basically, somebody's over 40. You saw pilots and drivers and things like that. There's things that you can do, but for people that are over 40, you can't discriminate based on age. So, mandatory retirement to a certain extent, retaliation for age-based things, whatnot. And as the workforce ages, I think you'll probably see more and more lawsuits and complaints about this. I'll let you read what do you do in the age. Again, I'll let you read the steps. Again, it's just like we talked about earlier on other types of discrimination. Replacing older workers with younger workers. Ooh, that's a big one, because let's say you come in as a new manager and you've got, 6 employees. You manage 10 employees. 6 of them are over 50. And and they've been there so long, they're making so much money, and your bonus is based on your profitability. If you can fire those 6 employees and hire people coming right out of college, you're probably going to save 50% of what you pay per year. I mean, that's amazing. So, but is that not age discrimination? So that's one of the bases that that a court or the EEOC could look in and say, wait a minute, you just wholesale got rid of older employees, and even just because you're doing it to save money and wages, that's still age discrimination. Okay. ADA, I'd like you to watch that YouTube video on the Americans with Disabilities Acts, and basically similar to what we talked about religion and other issues, an employer must make a reasonable accommodation. For example, if I have an employee in accounting, then I should have accessible offices. I should have doorways that a wheelchair can get in and out. You know, I should have bathrooms that are accessible. If an employee that's in a wheelchair that applies for, you know, being an NBA player or you know, lifting bags all day, well, you probably don't have to reasonably accommodate that person for that type of a job because it's not reasonable accommodation, right? There's a objectively reasonable test, right? So go ahead and watch that video. I think you will have seen in the video about what a disability is, and I'm going to reread them because basically it's a test that's right in the statute. It has to be physical or mental impairment that, and this is important, substantially limits one or more major life activities. Okay, got that? Second, there's a record of such impairment. In other words, you didn't just make it up. You've been to the doctor, you've got, you know, there's something that shows you have that impairment and that you have it individually. So also, what's a disability? Let's give examples. Alcoholism, AIDS, blindness, cancer. So sometimes diseases, not just physical handicaps or handicapables, you know, whatever's an appropriate terminology. There are certain diseases that can actually be a disability that are protected under the statute, meaning you can't discriminate or make job-related decisions based on that. So today, the Americans with Disability Act, well, I'm going to let you read that because you've seen that already in the video, but it's basically whether someone has a disability is on a case-by-case basis. The agency or the court looks into that individual. What is a reasonable accommodation without undue hardship? Good video on this. Please watch this. Same thing on this. So allowing the court to look in to make a fact-specific analysis. I want you to watch this video because it describes it well. Reasonable accommodation, there's another aspect of it. If it's in the pre-screening or employment application, I can disqualify you only if it makes it really impossible for you to perform your job without a reasonable accommodation. Substance abusers, okay, that can also be a basis for a disability, if you will, you know. There's the procedures again for proving that you've been discriminated against. I think it's cool to see that also there are federal protections against those in the armed services. They cannot be treated differently, and there are certain protections for job continuation, job promotion, hiring, et cetera, et cetera. So essentially, be aware of these and make sure your policies, read through the policies in your company, and especially in your department, and make sure that nothing there would, in practice or in implementation, would be discriminatory against someone in the military. For example, I mean, you just can't come out and say anyone that misses 30 days per year for whatever reason is going to be terminated. Well, if someone's away on active duty, you just simply cannot say that. It's against the law. Or if they're gone on Family Medical Leave Act, not military, but just family medical, you cannot do that. So look at your policies, look how they're implemented. Here's how, again, how to prove a case or a claim under the USERRA military protections. I'll let you read through that. Again, it's not just does someone get their job back when they came back, but if they would have been eligible to be reemployed or to have a higher job, promotions, that has to be considered as well when they return. You know that. Bona fide quality application. Same thing here that you've seen in other arenas. So they basically took the same language, the same rationale from, say, race discrimination, and it's also in this military anti-discrimination laws as well. So I'm not going to reread those. You can see those. Now, you may have heard of affirmative action programs, which are in danger at this point. Whether you agree with them or not, they're in danger. And essentially, usually government institutions, universities sometimes, I think well-intentioned, whether they achieve what they're intended to or not is really an open question. It's a debate. But I think well-intentioned programs try to give an equal opportunity to, all persons, and basically, especially for those who in the past may have been underrepresented, say, for example, in a university setting. So a couple things just for you knew that. Same thing with your work. You also likely have affirmative action programs, especially at some larger employers will do this. Sometimes you'll see what's known as reverse discrimination, so you have to be careful of that as well, because some companies get sued calling reverse discrimination. So you're not required to have that, but it's one of those laws that it's almost damned if you do, damned if you don't. You in many instances, you should do it to strive for equality in the workplace, and then other people may complain if you do it. So that's a tough one. You really need, if you do that, you really need to have legal advice about the specifics of what you can and cannot do so that you avoid lawsuits. Equal protection issues. An affirmative action program is constitutional, acceptable only if it does two things. It attempts to remedy past discrimination, and it doesn't use quotas or preferences. So that's tough. How does one do an affirmative action program without doing that? I don't know. That is challenging indeed. But the law in this area is evolving. All right, that's it for tonight. I do appreciate your paying attention, and I will say good night for this lecture.